Court calls the case, People versus Quadir Man.
Assistant Public Defender Ben Benowitz on behalf of Mr. Mann, who is standing to my right. Sir, would you say your name for the record, please?
Quadir Man.
Thank you.
Your Honor, we would like to set this matter for exam.
It came to my attention in looking at the defendant's jail calls before he was released and after he was arraigned. He made 50 calls to the victim from his PIN to her listed number after being arraigned. And that doesn't count the day that he was arraigned after he was arraigned. That only encompasses days exclusively after he was arraigned. He calls her 50 times. So I have concerns given that also at arraignment, the magistrate indicated his concerns that he will not follow court orders and that he would go back to contacting the victim as soon as he was released. And it seems that he didn't even do that prior to being released. He did it while he was still in custody. So I have concerns given now that he is out for safety. I also have concerns given the facts of this case in which his grandmother is the person who reported the crime after she awoke to blood-curdling screams from the victim and felt she had to call 911 after hearing the victim being slapped. So I have concerns for safety given that he was contacting her excessively from jail.
When was he released?
I'm sorry, could you?
When was he released from jail?
I believe it was the 26th and he was arraigned on the 24th after being arrested on the 23rd. Could I attempt to respond, Your Honor?
Go ahead.
My response is primarily based on the facts of the case. This complaining witness stated she was not assaulted. The grandma did not witness any sort of assault. As the prosecutor told you, she said she heard something. So there's no witness that actually witnessed an assault. So then, Your Honor, the police say he's laying on a mattress with a blanket on him, which we would commonly call sleeping. The complaining witness tells the police he has a head injury from falling down, okay? So he's sleeping and has a head injury. The facts of the felony charge in Washtenaw County in 2025 is that he had to be told 3 times to turn around and 4 times to back up. And that's a felony. And now we want to revoke his bond, which is basically a due process violation because you take away his trial right. His trial will be in about 8 months.
Why am I taking away his trial right?
Because if he's incarcerated, then it's make a get out of jail plea. I mean, he's talked to
It's not counsel. And quite frankly, this court resents that you even make that argument that this court would be involved in violation of anybody's due process rights. He's given conditions. If he does not follow those conditions, he pays the consequence.
I agree. I just indicate to the court, I don't think the person that the condition is regarding wants that condition. She didn't want any of this. And then
there's a way in which that's taken care of, not by him continuously calling. He knows he's not supposed to be
I mean, Your Honor, he's 19 and it's Christmas. I just asked the court to give him a chance until we have a date on the 13th. I mean, if this witness says he's contacting her currently, you know, she comes to court on the 13th and tells the court there's a bond violation. I clearly don't have an argument to that, but if the court would let him stay out till the 13th and he's not going to contact.
I don't know what he's doing now. I mean, that's what part of the problem is. Part of the problem is that, and by the way, not only is your client entitled to due process, but the people are entitled to due process. Everyone is entitled to due process, and it is my job to make sure that it happens. If I believe for whatever reason that he may be interfering with the people's due process rights to fairly present their witnesses and have their witnesses present, then I'll take action, which I'm about to do now. Right now, his bond is revoked. Defendant is remanded. Thank you. Yes, and his phone privileges while in jail are revoked. Put that, can you?
Would the court only revoke as to the 2 persons with no contact orders?
I'm revoking his phone privileges.
Okay, thank you.
State your name.
Joseph Hafner Cantor.
All right, what are we doing?
Your Honor, we're asking for a preliminary examination at this time.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me.
Where?
Bond continued. Thank you.
I think the last time we were here was December the 4th.
Pardon?
Last time we heard was December the 4th. I have a violation dated December the 9th. Bond violation. 4th.
And we are in receipt of that, Your Honor. I did review it with my client.
You have a bond violation? I do. Behind that, I need these in the front.
So Your Honor, it does seem to indicate,
We were here last on what day?
I thought December the 4th.
Yes, I have December 4th. And I've got,
So it does appear that these tests were in the interim period between the last time we were here and this.
Mr. Allen.
With positive alcohol blows on the silver link.
I've got a positive on December 8th. And then missed tests really through the 9th, early into the morning. So the 8th was at 11:37 p.m. 0.07. And then 04, probably the same alcohol, maybe a little bit more, by 8 a.m. that morning. So some 8 hours later, he's still blowing numbers. Except that then a little bit later, it popped up and then went down. So it looked like he was continuing to drink. Then the worst thing happened. They spoke with him, and he said he didn't have any alcohol.
And Your Honor, I believe Mr. Hafner Cantor is changing his position on that now.
Really?
He
Yes,
did
sir.
appear on the same day that since this string of events leading up to the court date on December 9th, I think he has pivoted and changed his position from denying
So let
his
me get this
problem.
right. You're telling me that all of a sudden everything has changed. On December 8th, he's drinking. He's drinking well into the morning on December 8th. He has to appear in court, can't stop drinking, and then ends up at court that day. He talks to community corrections, I think, on that same day and just is absolutely lying to them. And somehow between now and that date, he has made a certain epiphany has occurred and he's made some miraculous transformation. Is that what you're telling me?
Your Honor, I understand the court's concern. Mr. Hafner Cantor, when were you released from the Washtenaw County jail? Was it the following day or this?
I was there for a week. I think I was released on the 19th or the 18th.
So, Your Honor, he's strung together 10 days on a scram tether with no issues whatsoever. And I think that's what he wants the court to consider in reassessing bond here. I would ask the court to continue his bond based on the fact that he's come into compliance since being placed on the scram tether.
He's in violation on my case, goes to another court drunk.
And Your Honor, I would like to correct my record I made to make sure that it's accurate. Mr. Cook has let me know that he doesn't know if the defendant was individually touched at the court, but because he had the 0.04 30 minutes before the judge saw him, Mr. Cook's note was that he was drinking. So I apologize if that was confusing at all. I just want to make sure.
So he wasn't breathalyzed at court.
Now that Mr. Cook is aware,
Where
but
it's because it was 30 minutes before, there was an assumption that, which is a good assumption.
it's pretty fair. Yeah.
Anything else?
Your Honor, I know Mr. Hafner Cantor's been in constant contact with his community corrections agent, and I know that his 3-year-old daughter, who he takes care of, is his biggest concern. I think he was dealing with some stress regarding a custody situation with respect to his daughter, and
He's violated my bond. And then absolute disrespect showed up at another court still under the influence of his drinking event that violates his bond in this case. And he's appearing at that time on an OWI. And he's not in any treatment. Anything else?
Nothing for the beauty.
Nothing further, Your Honor.
Bond revoked, defendants remanded.
Your Honor,
Yeah.
and
The 13th is,
and with respect to that date, he does appear in district court on that same date. I'm not sure if the court wants to move it or if the jail would be able to accommodate that
district court where?
for the OWI case.
Well, we wouldn't pay him until much later.
Which judge is the exam?
Me.
Thank you, Your Honor.
Court calls case People versus Nicholas Harding.
Assistant Public Defender Doppy Lebo on behalf of Mr. Harding. Mr. Harding.
What you just witnessed wasn't a dramatic verdict or a high-stakes criminal trial, but in many ways, it was something even more real. This was everyday justice. The kind that plays out in housing courts across America, where real people face real consequences over rent, deadlines, and dollars that matter deeply to their lives. In today's session, we watched a tenant, Ms. Kazi, navigate the final steps of resolving an eviction proceeding. After confirming a $950 payment already sent to the landlord's office and a $200 payment made directly that morning, the court agreed to adjourn the matter 1 week for dismissal, without requiring her to appear. No judgment. No eviction. Just a clean resolution, provided the payments cleared. We also saw Mr. Redwine's case dismissed outright. And then there was Miss Brown, sitting quietly in that courtroom, anxiety written all over her face, not even knowing her case had already been dismissed. The judge noticed her, called her up, and sent her home with a smile. That moment? That's what courts are supposed to feel like. Not intimidating machinery, but a system that, at its best, still sees the human being standing in front of it. The lesson here is simple but powerful. Know your case, confirm your payments, and always, always, put your name in when you arrive. Because justice, even in a small housing court on a Friday afternoon, moves forward whether you're paying attention or not. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.